Good morning, everybody. Happy Tuesday, October 14th. Today I wanted to talk about one of the most hotly contested things I've got to deal with, and that is the issue of spousal support. It's usually one of the first questions that people ask me when they come in for a divorce or dissolution consultation, and unfortunately it's very hard to predict or give a certain answer. The Ohio Revised Code in section 3105.18 has a list of factors that the court is supposed to consider in every case in determining whether and how much to pay in spousal support and for how long. So those factors, the first one is the income of the parties. So obviously, the more money you make and the less money your spouse makes, the more likely you are going to have to pay spousal support. Number two, the relative earning abilities of the parties. So maybe one spouse is earning less than they could for whatever reason. They're considered underemployed. Number three, the ages and physical, mental, and emotional conditions of the parties. The retirement benefits of the parties, the duration of the marriage. Now, I will say this is not written anywhere in stone, but in Lake County and the surrounding counties, it's pretty well established that nearly all marriages that are 5 years or less are not probably going to have a spousal support number award, absent, strange circumstances. For example, a couple is married in California and the wife gives up her job and they move to Ohio to follow husband's career, and 3 years later he divorces her. You could see them ordering some spousal support in that short of a marriage. But for the most part, if both people are working, nobody gave up any employment or anything like that, any short-term marriage is probably not going to have a spousal support order. The extent to which it would be inappropriate for a party, because that party will be custodian of a minor child of the marriage, to seek employment outside the home. So if, we're talking about being underemployed, but then the question is, well, yeah, but we've got a 2-month-old baby at home, that's why I'm underemployed, then obviously that's going to be a factor the court will consider. The standard of living the parties established during the marriage, the relative extent of the education of the parties, the relative assets and liabilities of the party, including but not limited to any court-ordered payments by the parties, the contribution of each party to the education, training, or earning ability of the other party. Did we pay for, husband to get his doctor, to go through medical school while we were married? The time and expense necessary for the spouse who is seeking spousal support to acquire education, training, or job experience so that the spouse will be qualified to obtain appropriate employment. The tax consequences for each party of an award of spousal support. The lost income, production capacity of either party that resulted from that party's marital responsibilities. And the last one, and this is what makes it so hard to predict, quote, any other factor that the court expressly finds to be relevant and equitable. So what does that mean? It's very hard to tell. And most divorce cases that I've ever dealt with, all divorce cases I've ever dealt with, are either handled by one magistrate or one judge. So it is very unpredictable to determine what that judge is going to consider, quote, any other factor that is relevant and equitable. Which is why most of these cases resolve rather begrudgingly most of the time when it involves spousal support. But most of the times the parties are able to come to a number that they can both live with, whether they like it or not. There are some formulas that we're able to show people this is, a range of what it may be. But it's very unpredictable. And as you just read through the factors, the big ones are obviously the income and the length of the marriage. So hope everybody has a good week and talk to you soon.